Buenos días a todos y a todas. Empiezo saludando en español. Sé que muchos nos siguen tanto desde España como desde Chile y otros países de habla hispana. Les damos la bienvenida a este tercer encuentro chileno-germano-Tanzania de conversaciones en litigación climática. Y ahora voy a pasar al inglés. Welcome everybody to this event, the third Chilean German-Tanzanian Legal Talk on Climate Litigation. This event is organized by the Heidelberg University and the Tanzania German Center for Legal Studies with the University of Bayreuth and University of Dar es Salaam. I would like to introduce first to Professor Inés Ezio for a welcome words. Inés holds a degree in translation and interpreting from the Universidad Pontificia Comillas in Madrid, and a master's degree in applied linguistics to the teaching of Spanish as a foreign language from the Nebrija University. She worked at the Institute of Translation and Interpreting of Heidelberg University, and since 2020, she is the academic director of the Heidelberg Center at Santiago. Welcome, Inés, please.
Many thanks, Valentina, and good morning and good afternoon, almost good evening for some of you. I am very pleased to welcome you to what is already, as Valentina just said, the third edition of the Chilean German-Tanzanian Legal Talks, organized by the Tanzanian German Center for Eastern African Legal Studies at the University of Bayreuth in Germany, with the School of Law of the University of Dar es Salaam in Tanzania and the Heidelberg Centre Latin America in Santiago de Chile. A steady partner and co-organizer today is also the Faculty of Law at the University of Chile, and I am especially happy to welcome the experts from this university today, especially Professor Valentina Duran as the director of the Center for Environmental Law. For the third time now, our expert organizers and initiators have put together a very motivating program. We will hear 4 short talks by our 4 speakers on climate litigation. We live in a global society where topics such as bioeconomy, sustainability, right to a clean environment have become an indispensable part of disciplinary discourses, but also of non-disciplinary discourse. So it is of major importance to be aware of how climate-related challenges and issues are dealt with in different parts of the world. And that is the reason why we are here today. A further reason, however, is also being able to explore the many possibilities that academic exchange has for the advancement of science, since it helps us expand horizons and views beyond our very regional perspective and focus. Therefore, as in previous editions, this legal talk, this meeting, is a chance to intensify multilateral exchange and to promote the interest of early career researchers and senior researchers in exploring new insights and in sharing knowledge. So again, I thank very much all the institutions involved in today's talk. I thank the very kind support by the German Academic Exchange Service, the DAD, as well as the organizers, the speakers and moderators, and of course, all the participants attending the talk from different parts of the world. I wish you an interesting program and exchange, and I hope to see you again in the 4th edition in a couple of months. Many thanks and enjoy.
Thank you very much, Director Inés. And now I would like to introduce Toko Kaime. He is PhD in Law at School of Oriental and African Studies, University of London. He worked there until 2019 as a senior teaching fellow and founding member of the Law, Environment and Development Center and the School of Oriental and African Studies. He has also worked as a lecturer at several other British universities, and since 2019, he is the chairholder of African Legal Studies at the University of Bayreuth. So please, Toko, welcome. The floor is yours for some words.
Right. Thank you so much for that kind introduction. I would like to acknowledge our speakers today and the very interesting topic that they'll be discussing for and with us. Climate litigation is an area in which I have a particular interest, and we see how over the last couple of years it has grown in importance as a way of either advancing or delaying effective action on climate change. And it is crucial to see how it's spread within various different jurisdictions can be harnessed for the protection of the environment, but also mitigation of climate change. We see, especially for my interest, increasing use of human rights arguments to support this increasing number of cases. And it's quite exciting to see the kinds of innovations that lawyers are deploying in order to combat climate change by utilizing this framework that is accessed through human rights and I know that you will be discussing these many interesting cases that have been targeted at what we may call carbon majors and I really am looking forward to hearing your perspectives about the different strategies in the different jurisdictions. I would like to acknowledge all the organizers of the Legal Talk. This is an effort that is very much appreciated, and the ability to connect different places in this one space to discuss common interests and all of that. And I'm thankful that you are able to get us in one place in this way. And with these few words, I'd like to welcome everyone else to the Legal Talk. It is really great to see you today. Okay.
Thank you very much, Professor Toko Kaime. So I would like to say that climate litigation around the world has the potential to trigger and accelerate important changes. We see this phenomenon with a high interest at the Faculty of Law at the University of Chile, where I belong. Now we are discussing in our Congress the future Framework Climate Change Act, and we also, in a few weeks, we will begin the National Constitutional Convention, in which we will discuss certainly how Chile can incorporate climate change concerns in the fundamental text. In a few days, also on June 17th, we will host also a webinar on human rights and climate litigation from and to Iberoamerica. And later, the 21st of June, we will inaugurate a new project, an Environmental Constitution Observatory. And later, we have been actively working on how to make sure that as a country, we are prepared to face the climate emergency. Which, as we know, it is not only an environmental issue as we used to face it some years ago, but also a human rights, economic, social, cultural, historic challenge. So at the Environmental Law Center, we are very happy to be here. We appreciate very much this opportunity to exchange perspective and meet with leading scholars from Germany and Tanzanian University. So we really hope that this will be a success and that we will increase our collaboration. So now I would like to introduce Professor Jebi Gonza and ask you, Jebi, to introduce, you know who, our star Professor Lohse from Bayreuth. But please, Jebi, you're muted. You must turn on your mic.
Well, there's a point of correction there. I'm not a professor yet. I'm just doing my PhD. And so I feel privileged to introduce, to be given the opportunity to introduce Professor Dr. Eva Lohse, who happens to be my supervisor and the first speaker of this occasion. Professor Lohse pursued her Bachelor of Laws at the University of Friedrich Alexander Erlangen in 2004. In 2005, she completed her LLM in European and Comparative Law at the University of Kent, Canterbury, UK. In 2014, Professor Lohse graduated with a PhD at Friedrich Alexander University of Erlangen, again, Nuremberg. She completed her habilitation at the University of Freiburg in 2015. Currently, she's the chairholder of public law, namely administrative law, comparative law, and European law of the University of Bayreuth since October 2016. Professor Lohse is a lady of many academic works, as she has written extensively on these areas: European law, educational, administrative law, and comparative law. What makes her a potential candidate for this talk is that she has written and edited a lot of works on international environmental law. Indeed, I would like to just cite one of her important contributions among the many in the field of environmental law that she has edited with Margherita Ponto in 2015. It is titled Participatory Rights in the Environmental Decision-Making Process and the Implementation of the Aarhus Convention, a Comparative Perspective. Ladies and gentlemen, let's welcome Professor Eva Lohse.
Well, thank you for your kind introduction. I'm trying to share my screen, and then, yeah, I hope this will go along because I just had some internet problems. So I hope that this works now. Okay, I kind of changed a bit the title because I just like this, yeah, this quote: "Fish cannot go to court and trees don't have standing." They relate to two yeah, very famous contributions to this question: who can have access to courts, who can make claims, and can we give rights to the environment, to animals, to the climate as such, the atmosphere, whatever. This is not what I'm talking about today, but it's something that kind of moves me academically all the time. So I kind of wanted to have this relation in that talk. When we talk about climate change litigation, I just have to see, my internet is really sketchy today, but it works. If we talk about climate change litigation, and this is an illustration from a well-known German children's book that my parents read to me in the 1980s. So there might have been some, you know, putting me in the right way at that time. It's called I don't even know what it's called in English. It's kind of a mouse that lives underground, and it's fighting against these building sites, and obviously it can't fight against it, and there's no lobby for it. And yeah, that's the story of the children's book. But when we talk about climate change litigation, we are, as Toko has already said, very often focused on human rights, on international obligations, but mostly those cases come before yeah, national courts. and have to be solved using national law, national legislation, in order to be successful. And to give you another picture, I guess that's a picture that most of you can relate to. That's from a German newspaper, but it's the well-known Agenda case, the Netherlands, the Dutch case that started the whole thing off in Europe, at least. And those people who won the case against all odds. And obviously they won this case because there was Dutch legislation giving them standing in the first place, and Dutch legislation making their claim valid in the second place. And that's what I want to talk about today. So shifting away from human rights, I mean, they will play a role, but shifting away from human rights, shifting away from international law, and talking about the role of national legislation within climate change litigation. Just to run through this, I know that you all know about climate change litigation, and we will hear a bit more, but just to come back to the foundations. Usually it's based on human or fundamental rights taken from constitutions, from regional human rights conventions, or even from international human rights conventions. So the problem with that is they usually confer, with very few exceptions, individual rights, and they allow a protection against violations by state organs. So they might not be the right tool to really address problems that are brought about by climate change. Secondly, you can base them on national policy objectives. Most constitutions contain some provisions saying that the state has to follow sustainability goals, has to protect the environment, has to protect the climate. But in most legal orders, they are regarded as only objective rules, and they very often do not confer standing neither in front of constitutional courts nor in front of administrative courts or civil courts. So they are very good things to put into a constitution, but they are really bad when it comes to climate change litigation, because they don't give you standing, they don't give you material grounds where you can base your claim on. And the third leg it's based on are international conventions, like the Paris Convention as the most prominent international convention. But in many legal orders, it's not completely clear if and how they are binding, or even if they are binding, they might not be directly enforceable. They might need implementation by national legislation. So these are the problems that potential claimants face when they want to bring a lawsuit in climate change litigation. And then there's another thing. In the past, the focus has mostly been on governmental action. So we're looking at, has the government fulfilled its obligations under international law, under constitutional law, by drawing up climate protection plans and so on. But I think, and that's what I want to try to do in this talk on a very tentative basis, to shift the focus away from these inaction of governments, and to show that there might be use for a bigger involvement of, on the one hand, the legislation, the legislative power, the parliaments, and on the other hand, people who make laws, who are involved, participatorily involved into making laws. So that's what I'm trying to do today, trying to show that national legislation might be able to address those problems that the climate change litigation has faced so far when grounded on human rights or on international obligations. So what will I talk about and what I will not talk about? As I only have 20 minutes, or now probably less than 15 minutes, I will focus on this national climate change litigation. This means climate change litigation brought before national courts based on provisions of national law and not generally based on provisions of international law, and brought before those courts either by citizens of the respective legal order, or even people, as we have seen in the very recent decision by the German Federal Constitutional Court, also brought by people living somewhere in the world, in Nepal, in Indonesia, claiming that the German government, the German legislator has not valued their rights and has not protected them sufficiently against climate change. But I will focus on claims before national courts and brought on the basis of national law. So why do I do that? Because I think, being an administrative lawyer in the first place, that at some point we will need to look at national legislation, because, and I think that's true for most legal orders all over the world, national law, statutory law, has a governing function. It can direct the actions of the administration, of the executive, but also of people, of individuals, in a certain direction. And it has also an enabling function, again, both for the administration, because it gives them rights to intervene with the freedom, with the rights of the people, and enables also possible claimants. And then it's also, in most legal orders, due to the rule of law, it is essential to have some kind of legislation, to have some kind of law in order to have effective climate change measures that really encroach upon fundamental rights, that limit, for example, the right to property, the right to exercise a certain profession, and so on. So we need national legislation, and that's what I want to talk about now. Those are some cases that I will be using for illustration. I'm not telling you about all those cases in detail now, it would take way too long, but if you have any questions later on, I'm happy to answer them. I've included one case, which is not strictly a national case, but a European Union case, because it shows very well how, in this case, supranational provisions can prevent standing for potential claimants, because their case was never heard by the European Court. So this is included because it illustrates very well one point that I want to make. The Laya case is a civil law case of a Peruvian farmer against a very big energy company in Germany, RWE, and it's based on the claim that the farmer said they need to stop their carbon dioxide emissions in order to protect me from the perils of climate change. If they do not stop it, there might be an inundation of my village, and this violates my right to property, my right to life and health. Then I have a very similar German case, which is exclusively German. It's the so-called Pellworm claim. Pellworm is a very small island in the Northern Sea. And we have, again, farmers who claim that ineffective climate change legislation leads to them being ripped of their property, of their possibilities to pursue their profession in the future, and so on. Then I've already mentioned that The very recent case from March 2021 from the German Federal Constitutional Court. And it's an interesting case because it actually treats existing legislation, the Climate Protection Act, the German Climate Protection Acts, and using 110 pages for its decision, which is unusually long for a German decision, using those 110 pages in order to say, you haven't done enough. This Climate Protection Act is nice, but in a way you haven't done enough and you have violated the human rights of people already living in Germany and also of future generations. So this is an interesting case. And then I included two cases which show that this climate change litigation can be very tiny litigation. Once it was like 2018 in Austria, it was used to trying to prevent, I'm lacking the English word, well, the extension of the airport in Vienna. And again, a similar argument was used in the UK just recently, I think in 2020, in the Heathrow airport case. And it shows that it kind of is used in administrative law cases, this argument of we cannot allow this infrastructure measure because it furthers climate change. And then, of course, I will be looking a bit at the Urgenda case in the Netherlands and a very recent case also from France that I have dubbed now Grande Sainte. That's the name of the village that raised the claim that France has been inactive and did not value its international obligations. Okay, so that's the cases that I will mention, and I'm very happy if you have any questions later on to expand a bit on those cases. So what are the connections between climate change litigation and national legislation? I think we have to look at it in both ways. On the one hand, climate change litigation can be based on national legislation and can either be enabled, furthered, encouraged, enhanced by national legislation, or it can be prevented, or at least people can be deterred by national legislation to raise such claims. On the other hand, climate change litigation can be used to have more, better, or any national legislation at all. So to claim before the courts that the existing laws are not sufficient to fight climate change. So in a way, it's kind of like a circle, in my opinion. You have, on the one hand, control of existing national legislation or non-existing national legislation. You have, on the other hand, a function that it functions as a lever for litigation. And on the third hand, in some cases, climate change litigation will take a gap-filling function, meaning that it where there is no national legislation that would bind administrative bodies or that would demand measures to fight climate change, then a court might put up some kind of obligations, direct obligations in its decision, demanding mostly the government, sometimes, which is even more problematic, the legislator, to not only enact any kind of climate change or climate protection act, but to implement very specific measures. Okay, so that are the three functions that I could detect from the cases that I was looking at. So to look at them a bit more close, first of all, we have this function of controlling existing legislation, looking at it and deciding whether it complies with either international or national requirements for climate protection. And examples are the decision by the German Federal Court, obviously, but also the EU decision Carvalho, which treated EU directive, saying this EU directive, which in a way is about climate change protection, does not fulfill the requirements and does therefore violate human rights because it's not sufficient for climate protection. So the legal climb is, as I said, does the existing legislation fulfill constitutional, supranational, or international duties? If we use this kind of climate change litigation, we can have two results. Either the result is that the court accepts the claim and demands the legislator to widen the scope, add duties, adopt stricter laws, adopt laws at all. Or might also be that parts of the legislation which are seen as being detrimental to the climate or do not put as much emphasis as it would be needed on climate change, climate protection, that those parts of legislation must be abolished, must be modified. I haven't found an example for result 2, but I think academically it's a possible outcome of such legislation, of such litigation. Okay, yeah. So the other way of controlling would be we control not the legislator, not the lawmaking bodies, but we control those who have to implement, have to execute the existing norms. So we try to control either government or administrative bodies. And there are many examples. The mentioned Paulbaum claim, in a way, Urgenda, and the consent, as far as I could see from the decision as well. So the claim is there has been either governmental or administrative inaction despite binding legal provisions, or existing national laws have not been valued by the administrative. Therefore, they have, for example, if there's a decision on infrastructural measures and the administrative body has to balance different interests, this is usually the case in planning decisions, for example, the issue of climate change has not been given as much value as should have been when striking the balance. The result ideally should be the enforcement of these provisions. So the court would say that, yes, there has been inaction or the provision has been violated and there needs to be a new decision by the government or by the administrative. So those control decisions, in my opinion, they are not problematic as far as they, of course, control the implementation of existing binding norms and as far as they interpret those norms. But when they go down that way, that they come near the second function, which is here listed as the third, but I changed that around later on and I couldn't change my slides anymore. So the third one, or the second one, the gap filling function. The control of inactivity of the governments or of the legislators can get close to this kind of gap filling function when a national court demands very concrete measures of the government or the legislator. The most famous example is, of course, Gender, where the Dutch court ruled that the Dutch government has not fulfilled its obligations under the Paris Convention and demanding in all instances that the Dutch government needs to implement effective measure in order to meet its greenhouse gas reduction goals by the end of 2020. Now we are already in 2021. I couldn't really find any documentation if anything has happened, but on a legal, on an academic basis, what are those cases? They claim inaction of the government again, and as in the French case, for example, that there exists no national legislation to implement climate protection on a national level. So what they want is that the government or the legislator becomes effective, and the result of a successful claim will be an maybe even enforceable, but this of course is moot, obligation of the government or the legislative to pursue rather concrete measures or to reach certain goals. What's the problem with this?
Eva?
Yeah.
It's time.
Can I just say the third one very quickly? Okay.
Of course.
I just wanted to wanted to get on the third one because that's, in my opinion, the most important thing, that you have to realize you need national legislation on the one hand, because you have a procedural lag. You need to grant standing, and you can only do that in most cases by national legislation. And you need grounds for action, and they can also mostly only be found on an effective way in national legislation. So that's something that you need to think about. And to finish off, if you know all that, so I don't have to show you that. Those are the 6 points that I think that national legislation can actually change, or what we can change and what needs to change in national legislation and via national legislation. They can establish a connection between participation and sustainability. They can grant standing. They can issue modifications to legal subjectivity, so there are more legal subjects, or you could abolish the connection between standing and legal subjectivity in order to give standing to more in more cases. You could establish causality, even if you have only diffuse encroachment upon rights. Of course, you can put there very concrete measures and obligations, even for individuals, which you can only do by statutory law, national law. And finally, you can have standards of legality and aspects for balancing, so you can guide administrative decisions in climate protection. And I think, I hope I made my point that we need national legislation to have successful climate change litigation. I'm looking forward to your remarks and the discussion.
Thank you very much, Professor Eva Lohse. It was very interesting. So I propose to answer some questions at the end with the other professors. And now I would like to introduce the real organizer of this event, Sven Corsilius. Please, and ask you, Sven, to now introduce the next professor.
Yeah, thank you very much, Valentina. And thank you for being here, everybody. I'm very happy that we are in the 3rd edition already of the event. Thank you very much to the co-organizer, Javi Gonza. We had much fun and worked very well together in the last weeks. It was really a great pleasure to prepare this event for you. The next speaker as well, still not is a professor, but already worked a lot for her young age. She finished her legal studies at Heidelberg University last year in 2020, where she passed the typical German first state exam. Currently, she is a doctoral candidate at the chair of Professor Dr. Weller at the Institute of Foreign and International Private and Commercial Law in Heidelberg. She is researching on our subject matter on cross-border climate change litigation, in particular on the question of the effect of plant permits and emission authorizations on private law. At the same time, she works in Frankfurt for a large commercial law firm in the area of mergers and acquisitions. And I think this is very interesting to mention. She already published her first articles on this subject matter, and she collaborated in a very interesting book which appeared at Heidelberg University from Professors Karl and Weller. If you want, you can maybe post the link to the book. I think this collaboration in the book was really very interesting. Ah, you have it in hand. Better. You are, yeah, in Germany you get it. Here in Chile, the hardcover still did not arrive. So the floor is yours, Mai-Lan Tan. Thank you very much for accepting our invitation.
Thank you. I will also try to share my screen with you. So I hope it works. So thank you for the invitation to this panel and the kind introduction. I'm very pleased to present to you excerpts from the essay I recently wrote with Professor Dr. Weller. Climate change litigation is booming. Climate change is increasingly being brought before the courts. I will take a closer look at civil climate change litigation, a field of climate change litigation in which also public interest has grown exponentially with the landmark ruling of, again, a Dutch court against Shell 2 weeks ago. The increasing public visibility correlates with increasing numbers. Climate change litigation, or simply climate litigation, has been growing in importance over the past 3 decades. The majority of climate litigation recorded since 1986 have occurred from the mid-2000s onwards. First of all, please allow me to briefly explain the structure of my presentation. In the first step, I will distinguish the so-called civil climate litigation from the, at least according to German understanding, public climate litigation. We will then take a look at only a few selected cases from different countries in order to discuss cross-jurisdictional hurdles of civil climate litigation. I will focus on climate litigation in the narrower sense. That means on those proceedings that do not attack a single regional project, but rather deal with the effects of private action on the global scale, and with special regard to tort law and corporate law. At the end of my presentation stands the question of justiciability in this context. So, global climate protection is primarily a task of international law and public law. Yet, despite first successes in the battle against the temperature rise, political measures often take long and lack ambition to bring about the necessary transformation of the economic and energy system. In light of this, it is not astonishing that the vast majority of climate litigation worldwide has been brought against governments. This, according to German understanding, public climate litigation takes place in the vertical relationship between citizen and government. They can aim, for instance, to force authorities to take more effective measures to reduce emissions. Civil actions place horizontally between private parties. They're usually directed against corporations that are held to contribute to greenhouse gas emissions, for example, the fossil fuel industries. Such actions account for around 25% of climate change litigation worldwide, 20% in the United States. So before moving on with civil climate litigation, I will also present to you some examples of public climate litigation. The landmark litigation of Cordella has already been mentioned, and it's subject of much interest and public attention since its first success in 2015. I will also come back to this decision later. Since then, since 2015, individuals and communities around the world have initiated proceedings against states seeking to achieve similar rulings. In Germany, as we already heard, such an initiative was also partially crowned with success, since the Federal Constitutional Court declared that the Federal Climate Protection Act is partially unconstitutional. It declared that the complainants, some of whom are still very young, had their liberties violated by the provisions of the law, which irreversibly postpone high emission reduction burdens to periods after 2030. In other countries of the world, such as Brazil, the Czech Republic, or the United Kingdom, decisions are still pending. So let's now turn our attention to private climate change litigation and so-called private enforcement. Private law and civil courts have an essential function alongside public enforcement. The first essential function is leverage. The enforcement of public law guarantees can be significantly increased by activating citizens. There are numerous areas of law that have experienced an enormous increase in importance precisely because they have been open to private enforcement. You can think of European law, cases are Fangent and Lohse, or antitrust law, or German treaty, and also human rights litigation. On the other hand, private law can give the guarantees of fundamental and human rights substantive precision and thus practical effectiveness. Fundamental and human rights have enforcement weaknesses when they're used in a horizontal relationship. Firstly, they're usually formulated so vaguely and so generally that they are not in themselves suitable as deductible judicial decision-making norms. For example, it's hardly possible to condense the right to protection of the natural basis into concrete rules on emission reduction. Secondly, international and public law do not provide a general sanctioning regime for private individuals who violate its provisions. Thirdly, international and public law lack mechanisms for legal action against private parties. These deficits in the enforcement can be remedied if private law is used as a complementary regime to public law guarantees. And the last point I want to mention is that some of the cases are designed to reach outcomes that go beyond the scope of the individual case at hand. It's so-called strategic litigation that seeks to advance also climate policies, to drive behavioral shift by key actors, to create awareness and encourage public debate. Now, I want to move on with some cases. The United States qualifies with over 700 to 800 climate change induced lawsuits as the front runner in this area. The first such lawsuit, Connecticut and American Electric Powers, was filed in July 2004. The claimant sought imposition of caps on and reduction of greenhouse gas emissions. Defendants were 6 of the biggest emitters of greenhouse gases in the United States. The district court dismissed the case, stating that the matters raised a political question that can only be addressed by the political powers, leaving the court without any jurisdiction. This reasoning is called as political question doctrine. The Supreme Court took another part. It held that the federal common law on which the plaintiffs had relied in this case was superseded by the Clean Air Act, which confers the authority to regulate greenhouse gas emissions to the Environmental Protection Agency. The outcome was the same. The Supreme Court dismissed the case. This reasoning of AEP is still prevailing today and was followed, for example, also by the Court of Appeal in the case of native village of Kivalina and ExxonMobil Corporation. The lawsuit against more than 20 large energy companies was filed in 2008 by a small Inuit tribe together with the town of Kivalina because of the threat of flooding of their settlement. Another hurdle of civil climate change litigation can be seen in Natcoma and Murphy Oil, United States, a 2005 lawsuit brought by Mississippi residents to compensate for property damage caused by Hurricane Katrina. Here, cause already negated the plaintiff's standing. The court denied a sufficient causal connection between the injury and the defendant's emission. Following this first wave of unsuccessful lawsuits against major fossil fuel companies in the early 2000s, over the past 5 years, a new wave of civil climate change lawsuits have been filed. You can see another few examples on the timeline. The plaintiffs in this new wave are now relying on the state's court in a hope that the state common law, in contrast to the federal common law, is not preempted by the Federal Clean Air Act as held in American Electric Powers. The Second Circuit, one of the 13 federal appellate courts, however, hold in the city of New York and PPLC on 1st April this year, that the federal common law displaces also New York state law. A final say by the US Supreme Court on this issue is lacking so far. Now we look at the United Kingdom. Case material is lacking in the field of civil climate change litigation so far. However, voices in the literature test future potential. Blueprints could be provided by the viable human rights litigation. In a leading decision in 2019, the UK Supreme Court pushed open the door for action against foreign group subsidiaries and the UK parent companies in the United Kingdom. It affirmed the international jurisdiction of English courts over a related action against a Zambian subsidiary and its UK parent Vedanta plc. The decision is particularly explosive because of the United Kingdom Supreme Court's incisive reasoning on substantive tort law. It held that the British parent company could be held directly liable for alleged environmental damage and human rights violations committed by the foreign subsidiary. This line was also most recently confirmed by another UK Supreme Court decision, Okpabi and Royal Dutch Shell plc. New impulses in the field of private enforcement, or way less along the lines of classical climate litigation, were indirectly initiated by Shell itself. It has recently asked investors to vote on its energy or climate change strategy. A UK pension funds group commented that the strategy does not go far enough and demanded it be aligned with the Paris Climate Agreement. They argued investors should advise against in an upcoming meeting. Now let's look at the Netherlands. They are one of the pioneers in climate litigation. The landmark litigation of Urtenda has been mentioned. The Supreme Court of the Netherlands put the Dutch government under an obligation to reduce its greenhouse gas emissions by 25% instead of 20% by the end of 2020, compared to the reference year 1990. There are several aspects of the judgment that offer possible lessons for future cases. From the point of view of private law, it's particularly exciting that the action was based on an article of the Dutch Civil Code that provides the basis for claims for damages that arise from torts, and that the court referred to a duty of care, which is a classical institute of private law. This aspect probably also inspired the environmental group Milieu de France, Friends of the Earth Netherlands. They, as you might know, successfully served a court summons alleging Shell's contributions to climate change violate its duty of care under Dutch law and human rights obligations. In the landmark decision 2 weeks ago, a court in The Hague has ordered Shell to cut its global carbon emissions by 45% by the end of 2030 compared with 2019 levels. Shell was told that it had a duty of care and that the level of emission reduction of Shell and its suppliers and buyers should be brought into line with the Paris Climate Agreement. Now let's look at France. In France, public climate litigation could also create such impetus for civil climate litigation. In a lawsuit of 4 NGOs against the French state, so-called Affaire du siècle, the plaintiffs achieved a first success in February this year. The Paris Administrative Court ruled that the French state is fundamentally responsible for failures in the fight against climate change. But litigants have also been trying already yet to expand strategies based on the concepts of duty of care and duty of vigilance. For example, in Notre Affaire à tous and Total, an alliance of French NGOs and local governments filed a complaint against oil major Total. The complaint is based on the famous 2017 French law of vigilance, which requires a company to produce a plan of vigilance that identifies and seeks to mitigate risks to human rights, fundamental freedoms, the environment, and public health that could result directly or even indirectly from the operations of the company and of the company it controls. The plaintiffs in this case sought a court order forcing Total to issue a new vigilance plan that considered, amongst others, the risk related to global warming and Total's contributions to those risks. Although the complaint was dismissed, with the court concluding that the case should have been brought before a commercial court, this case could inspire other similar legal actions aiming to hold carbon major corporation to higher standards for climate responsibility. Now, finally, Germany. The political response to the recent decision of the Federal Constitutional Court was not long in coming in Germany. In mid-May, the Federal Cabinet already passed an amendment to the Climate Protection Act. Whether and to what extent the ruling will also have an impact on civil law is yet not foreseeable. However, the Federal Constitutional Court leaves no doubt that a social and corporate rethink will be necessary in order to achieve climate neutrality. However, the civil law literature has been occupied since 2015 by the also already mentioned lawsuit filed by the Peruvian farmer Lua, which is now still pending before the higher regional court of Hamm. Lua considers the German energy company RWE to be partly responsible for climate change, given its estimated share of 0.47% of global greenhouse gas emissions. He is demanding pro rata compensation for expenses incurred to protect his property, which is in danger of being flooded by the climate change-induced swelling of a nearby glacier lake. What is especially exciting here is the course of action. Section 2004 of the German Civil Code, in contrast to classical tort law, does not require fault on the part of the defendant. So, to conclude, so far, civil climate litigation has rarely been successful. Claims for damages, not at all. Those cross-jurisdictional legal obstacles can be identified. First of all, there needs to be a basis for the claims. They can be essentially found in tort law and in property protection law. In some cases, legal systems also provide for specific environmental liability in addition. German law, for example, provides for strict liability of installations in the case of environmental impacts. On this basis, defense claims, claims for damages, and claims for compensation for precautionary measures can be asserted. Differences arise with regard to the legal interests protected. The common law also recognizes rights common to the general public, such as communities' health, safety, or overall welfare with the institute of public nuisance. Civil law systems, in contrast, primarily focus on the violation of individual legal interests. Under German tort law, for example, only such environmental damage is sanctioned under tort law that has actually led to a violation of an absolute legal interest. For example, a violation of property or an injury to life or limb. Climatic phenomena as such as drought or heat, on the other hand, are not sufficient. The climate or the environment as such are not recognized as absolute rights. Neither are assets as such. So take an example. If a ski lift operator suffers a loss of earnings due to a lack of snowfall, he basically goes empty-handed under German tort law for so-called pure financial loss. Causality presents itself as a further fundamental problem of all liability bases. The scientific cause and effect uncertainties of emissions, global temperature increase, and its effects of sea level, melting glaciers, and individual weather extremes are reflected in the question of causality. A mere statistical increase in extreme weather events does not meet the requirements of equivalent and adequate causality. But litigation continues to benefit from advancement in climate attribution research to establish a strong causal connection between anthropogenic greenhouse gas emissions, an increase in the global temperature, and the likelihood of individual weather events. The last issue I now want to mention is the criterion of illegality. The crucial question also the court at The Hague addressed is, did and do operators of power plants have a duty to emit a lower quantity of greenhouse gases or to take climate-friendly measures? What is here the significance of public law permits and public law emission trading systems? Are allowances and permits also considered outside the legal system in which they were issued or acquired? So with these questions, I want to turn now to corporate law, because corporate law, in contrast to tort liability, is less concerned with causality and the difficult questions of illegality. The focus is less on past emissions than on current and future corporate behavior. The latest successful moves of Chevron's and Exxon shareholders underscore growing investor push at energy companies to reduce their carbon footprint. Corporate law cases may stem from shareholders of banks, pensions, and investment funds criticizing a failure to adequately disclose climate risks. Other actions aim to oblige corporations not only to disclose, but also to incorporate climate risk into their decision-making process and adapt their business or investment model accordingly. It's not only about making the business itself climate change proof, but also, especially in the fossil fuel industry, to adjust the business model considering necessary future climate neutrality. In recent times, corporate purpose is also once again being discussed. Some authors argue that corporate purpose is more than just profit-making. Companies should really see themselves as institutions that develop solutions for the community and the environment. This due diligence could also feed back into managers' due diligence under corporate law. Corporate law may as such become a Trojan horse in civil climate litigation. Finally, I would like to close the circle between public and private climate change litigation. If individuals go to court against governments to sue for more ambitious climate policies, the question of the separation of power becomes an elephant in the room. Many of the problems I mentioned during my presentation show, however, that the question of justiciability also arises in civil climate litigation. US courts have been particularly blunt in formulating this problem. In Connecticut and American electric power, for example, as you can see, it was said, cases presenting political questions are consigned to the political branches that are accountable to the people, not to the judiciary. And the judiciary is without any power to resolve them. This is one of those cases. The decision in People of the State of California and General Motors Corporation, another civil climate change case, reads similarly. The adjudication of plaintiff's claim would require the court to balance the competing interests of reducing global warming emissions and the interest of advancing and preserving economic and industrial development. The balancing of those competing interests is a type of initial policy determination to be made by the political branches and not this court. In Germany, however, these questions are discussed less in procedural law than in substantive law and are contextualized in figures of tort law such as adequate causality and illegality, as are presented. If courts do not address this intricate problem, there's a danger of private over-enforcement, I'd say, which could call the legitimacy of decisions into question. I conclude with this plea and thank you a lot for your attention. I look forward to a stimulating discussion and your questions. Should you have any further questions following today's event, please feel free to send me an email at the address provided.
Thank you very much, Mai-Lan Tan, for your interesting presentation. I now ask Debbie to introduce next lecturer. Are you there, Debbie?
Yes, I'm here.
Okay.
Yeah, so it's an honor to introduce the third speaker for the presentation in the person of Dr. Cleophace Morris. Dr. Morris is one of the few scholars we have in environmental law in Tanzania. And Dr. Cleophace Morris had his Bachelor of Laws at the University of Dar es Salaam in the year 2000. And he pursued a Master's of Laws in the year 2004. After that, he achieved a PhD at the University of Dar es Salaam in 2019. Dr. Morris specialized in climate change, and his PhD thesis was titled Analysis of Implementation of the United Nations Convention of the United Nations Framework Convention on Climate Change in mainland Tanzania. Dr. Morris is an advocate of the High Court of Tanzania and subordinate courts there too. He teaches several courses, including jurisprudence, commercial law, legal ethics, and civil procedure. Ladies and gentlemen, shall we welcome Dr. Morris to give us his presentation?
Yes, thank you, JB, and the rest of the members here. As it has been said, yes, I salute you from Dar es Salaam. I have a paper that I've prepared. I wonder whether it will be seen from your side. I'll be talking a little bit about litigation on climate change in the perspectives of the Tanzanian law and rule regime. I'm interested in sharing very briefly the context of climate change, not only in Tanzanian perspective, probably with a view to share what an East African environment in climate change aspects is all about. So my discussion covers a bit of the position of the Tanzanian law on climate change and the legislative agenda that is relevant to climate change in this country. But I'm also interested in discussing very briefly the international commitment on climate change in the view of the Tanzanian jurisprudence. And probably I would share a bit of what is the court's role in making sure that it is contributing something on climate change in perspectives of whatever the others have shared. Well, the presentation itself is based on the premises that just like it is for the effects of climate change, Tanzania being one of the countries that is in the on a lower side on the contributing of the greenhouse gases, there are quite a limited discussions in courts and discussions in political spheres of climate change as it is elsewhere, because the experience that I've just gotten from the presenters who have been presenting before me, you realize that there's been a lot in terms of the court litigation in different perspectives of the countries that are coming from. But all the same, we are not saying we are living in an island. Tanzania is also part of the problem of climate change, and therefore it can't shut doors. It has to work. It has to work very hard to make sure that things move from worse to better, in line with whatever the international agenda is all about, insofar as global warming is concerned. Now, Tanzania is from the framework of law, is adopted itself, or it is ratified both the UNFCCC and the Paris Agreement, with a view to join the global war, targeting to limit the global warming to the targeted levels. But all the same, there are challenges that are still facing the country, not only on an individual perspectives, but also from the regional trend, because it is part of the East African community. And within that, there are quite a lot of information, a lot of strategies that have been put in place to make sure that climate change is not only fought by the individual countries, but it is capable of being fought by member states jointly and exclusively. Now, it has to be taken from this line that the commitment of countries such as Tanzania to the international fight against climate change is not as probably some other jurisprudence have taken it. Because firstly, Tanzania, amongst the countries of the category that it falls in, is supposed to protect the climate system for the benefit of present and future generations. That is one of the commitments in the international law or tenets. But again, it is also supposed to take appropriate measures to anticipate, to prevent and minimize climate change causes that are caused within the country and or beyond the country. By taking initiatives in terms of mitigating strategies to curb and put it down to sizable emissions. But it also commits itself to make sure that the policies and the measures that are taken within sectoral advancements take climate change within the context of making development work hand in hand with safety to climate. But again, it is supposed to protect and enhance sinks and reservoir for GHGs. And finally, Tanzania is also committing itself to communicate to the meetings of international forum on how it is doing in terms of climate change and mitigating strategies it is implementing. Now, with all these particular efforts that Tanzania might have devised, there are quite a number of information that are still missing, and there are still a lot of efforts to be taken, not only on the ministerial positions in ministerial and all government and political levels, but also it is something of a lot to do in terms of the litigation in courts. If at all, courts have to contribute quite significantly to litigation on climate change. Now, a few positive framework strategies that Tanzania benefits from in this line. It is one, as I said, it is ratified UNFCCC, the protocol in Kyoto and the Paris Agreement. But it also has policies in place to make sure that it protects environment, which is in line with the spirit of climate change protection. You have quite a number of these policies, like the National Environmental Policy that was done in 1997, and it has been reviewed. There's an energy policy of 2015. There's a National Forest Policy of 1998. There's a National Agricultural Policy. You also have the Constitution of the country, which is also putting an obligation to every citizen to make sure that they are not only safeguarding and protecting the natural resources, but also they are up to a task of making sure that they do that sustainably. But also have a specific law that is covering the sustainability of environment, and more so to deal with few areas of climate change in that light. Like as an example, we have that law establishing an oversight council, that is the National Environmental Management Council, to make sure that it all goes into making sure that the environment is protected to a sustainable level. But it also, that law subordinates other laws and ministerial functions to this particular specific law on environment, such that if there's any conflict between the laws and the ministerial decrees, then the law on environment prevails. So that is also another positive move. But we also have specific projects subjected to making sure that they are implemented subject to approvals of environmental impact assessments and constant reviews. We also have the environmental fund that has been established, but it is yet to take off in making sure that it rehabilitates the environmental damage that might have taken up. But this particular specific law, again, dedicates quite significant coverage on the domestic implementation of international agreements on environmental protection and all multilateral environmental agreements that the country has ratified or signed. But it also outlines measures on climate change that the minister who is responsible for environment should on day-to-day basis oversee the adoption of measures that will assist to fight against the climate change in every sector of the economic development. But that all by itself, we also have a number of sectoral laws that invariably have the provisions to make sure that the environment is protected, and therefore indirectly the climate change is also put in the picture. As an example, we have the Electricity Act, which promotes the use of electricity on a large scale, but monitoring the effect it might have on the environment. We have the Mining Act being amended from time to time, but at least amongst the other attributes that are very useful for environmental sustainability is the provision that deals with the polluter pays as a principle. So it supplements the specific environmental law statute in terms of making sure that the environment is protected. But it also establishes, there's an establishment of the climate change institutions, like the National Action Plan on Climate Change, we have the National Adaptation Plan on Action, we have the National Climate Change Strategy, we have the National Climate Change Steering Committee, and we also have some sectoral reforms and projects that have been put to make sure that the climate change negative effects are brought backward. But there's still quite a lot from this coverage when it comes to regime. That regime itself is not as effective. It will lay down a very better foundation for climate change litigation or use of the court to making sure that climate change is also brought to forefront. One of the weaknesses that we find out in this line of event is that in as much as we have ratified the international treaties and or instruments to protect the climate, these statutes have not been domesticated. There's no specific legislation for implementing such conventions or the protocol or even the agreements on Paris and the commitments that are there. We also face another challenge that there's no clear and committal article in the Constitution or a section in the Constitution that will make clean and healthy environment, so to speak, climate change, one of the basic rights for someone to go and fight in court. But again, the specific law on environment was enacted in as much as we had the climate change already as a problem on a global portfolio. This specific law simply treats climate change not as a particular problem. It simply takes it to be just like any other environmental problem. It is, as an example, a section which allows that climate change should be dealt with administratively, just like any other environmental problem, which marks it to be a less vigorous approach to climate change, which is a serious problem. And again, it is section 75 of the same law. It is proposing against the UNFCCC and international outlook on climate change reality, because it allows fossil fuels like coal and petrol to still be largely promoted in the country, which is against the objective of the United Nations framework on climate change. But also we have some provisions in that law which are inconsistent. In some of the statutes, we have the minister responsible for electricity, as an example, who is mandated to promote indigenous energy resources in the country. Now, there's a lack of definition of what exactly indigenous resources are. And this open-ended kind of formulation of law is leaving quite a lot to be desired, because it leads to promotion of some fossil fuels, which are otherwise contributing to emissions of GHG. And as a result, somehow, some of the investors have been allowed to, even out of subsidized strategy, to use this coal as a source of energy in the country. We also have less specific legislation on climate change, and therefore this scattered line of legislation will just be patchy. You simply get one from another sectoral law, you get another one from another sectoral law, and it can't contradict at some point in time. And again, we have legislation which is not clearly defining the scope of the Tanzanian commitment to the international instruments to fight against climate change. And when it, as I said, it promotes coal production and use in the generation of electricity, both in the energy policy and in the Electricity Act, as I said earlier. But again, we have the law which tries to promote rural energy. And amongst the definitions that are given in that law is the modern energy, which include petroleum and other energy forms of higher heating and energy content in value. If you go into scientific analysis of whatever that is, you find out that some of the fuels that have been or that are being prevented by the international climate change regime are being promoted yet from another line of law in Tanzania. We also have no clear timeline in terms of implementing the commitments of the country to implement the UNFCCC agenda. And again, we have no policy in place to present and promote climate change. Now, if you allow me, members, I will speak again on the domestic court's interpretation on international and national obligation to climate change. Litigation in domestic courts, just like it has been said by the other presenters, is said to be one of the severe and very effective instruments to fighting climate change, because this is where some of the provisions of the statutes are interpreted, and this is where you now get to hold responsible those who pollute and later on cause emissions of gases that are otherwise harmful to the environment and climate. And it is, of course, has been likened to a magic bullet. The courts are said to be the magic bullet against climate change. So if at all there's anything that has to be very effective in this line, it has to be taken from a court perspectives. And that has always been in the protection of environment and protection of climate. Now, in Tanzania, it has to be taken from an area that environment is not a union matter, but meteorology is where climate change now falls in. However, we have had fewer lines of how to get to litigate in terms of climate change. As I speak, I've researched and there's not been any case on climate change in court. There's no pending court litigation on climate change in Tanzania, but also the cases that have so far been litigated on are mostly on environmental protection. And some of them are just put at the principles of environmental protection have just been spoken out by passing, just like it's not an interest of the court to deal with them very specifically. But even then, even if you go for environmental protection litigation, which is a very small element of climate change protection, you find out that you have quite a number of delayed outcomes when you go for environmental protection cases. There's a delay which hamper the objective as to why you go to court. But also face a lack of environmental knowledge and skills to some judicial members, litigants, and of course, lawyers in general. We also have inadequate skills and we have inadequate in skills and active participation of the practitioners in the environmental and the climate change litigation. We have few stakeholders who are interested in litigating this kind of cases, but also lack the tailor-made procedural rules, which could just be made to be user-friendly in litigating to protect the environment and the climate change, the climate in general. And then the decisions that are being given on the policies that have been put in court for translation, they all deal with the environment and environmental protection as a passing by, but they are not in any way very useful to that level. So if you're looking at the Tanzanian perspective of climate change in terms of litigation, you really find quite little to gain. And if you force the environmental cases that have been litigated, they don't give you a very quite clear niche of litigation of climate change in this particular country. And there are quite a number of reasons why this has been the causes. If you lack a specific law, as an example, or if you don't have a constitutional mandate to litigate on climate, some of these become a little bit of complicated, kind of like you are far-fetching this from somewhere. If you get an example from Kenya or Rwanda, like if you go to Kenya, they've a categorical section of climate change in their law. And it says that any person, pursuant to Article 70 of the Constitution of Kenya, may apply to the environmental and land court to allege that a person has acted in a manner that has or is likely to adversely affect efforts towards mitigation and adaptation of the effect of climate change. Now, you don't find such phraseology in the local provisions of law. Now, in the absence of such clear direction of a statutory provision, even if someone would be interested in go fight or litigate on climate change, you'll simply be patching in some elements of the law from Environmental Act, which in itself is not so particular and it's not so specific. In this regard, therefore, there's little effort that an individual put across to fight against climate change in Tanzania. Now, allow me, members, to speak about the role of non-actors, non-state actors in this regard.
Professor Morris, we are on time.
Yeah, can I finish?
So please try to close your presentation.
Yes, I'm doing this. I'm almost there. Now,
okay.
If there's any useful tool to fight against the climate change, it would have been the non-state actors, because in most cases, the state would promote the opposite. Now, the non-state actors in Tanzania have not done quite a lot in this area. If you go research, you find that quite a lot of them, because of several factors, they are not giving out a very helping hand in litigating against climate change. Most of them are based in the major cities where indeed you really find too much to do with climate change problems. They also lack the suitable platform within which to act. If they don't themselves know exactly where to go. They also lack skills on what they need to litigate on. They face protracted government hierarchies when they try to fight or put in the policy across. But again, they have poor representation of the stakeholders in the peripheral. They are not penetrating to the peripherals, and therefore they're quite little to learn. And therefore there's unclear and little public-private partnership opportunities between the non-stakeholders and that. Now that said, therefore, I'll be concluding by saying we still have quite a lot to learn from those who are already fighting in courts. We need to really go into people who are litigant really, and the public litigation in this regard should be geared towards not only protecting the environment, but should be taken further to assist in the climate change, which is, in most cases, it has been taken to be a new phenomenon in most of us, in as much as it has been on the ground in other jurisdictions quite a long time ago. So if you allow me to conclude, I'll be saying it is not only the political will, but it also has gone to the lawyer's mind that it is their role to contribute quite significantly in terms of protection of the environment and climate as well. Thank you very much for that time you've given me.
Thank you very much, Professor Morris. I'm sorry to interrupt you. We are just on time. We are receiving your question by the chat, and at the end we will talk about. Now I would like to introduce Professor Ezio Costa, my friend. He is a master in regulation and PhD in law. He's a professor at the University of Chile Law School and at the Regulation and Competition Center, also from the law school, as well as he's also part of the economic law department, and he teaches at the engineering school, also at the University of Chile. He combines very successfully scholar activity and life and academic life with a strong civil society activity and leadership, since he's also executive director of the NGO FIMA, where he has worked as a lawyer for communities and people affected by environmental conflict since 2006. Please, Ezio, adelante.
Thank you very much, Valentina, Sven, for the organization, and everybody who is here to hear us and to participate in this event. I will speak about climate litigation in Latin America, and I hope that at the end of this presentation, we can be on the same page about the climate change in Latin America. We will do an overview about the effects of climate change down here, and therefore, which are the rationales for climate litigations that are not exactly the same that has been in use in other places of the world. Some of the things that I will speak about are very connected with the presentation of Eva at the first presentation, because we are both exploring the rationales of climate litigations, but I do believe that in Latin America, and looking at the cases in Latin America, we can find some differences that can help in the research about climate litigation in the global north and in the global south. So let's start then with some data about climate change in Latin America. We are a region that is very worried about climate change. And this is both a good news and bad news. The good side of it is the fact that since we are very worried about climate change and we believe that it's a very serious problem and that it's harming people already in Latin America, we have a political disposition to change that I think it's a little bit bigger than in other places, particularly more bigger than in our neighbor in the north, no? But the bad side of it is that this fact is connected with the fact that we are already seeing the harms that climate change produces. So it's not just that we are worried about something that is going to happen in the future, but that we are worried about things that are already happening in Latin America. We are very worried in Chile about a drought that it has been going for the last 10 years at least in the central part of Chile, and apparently it's going to be our new reality. We are very worried about the loss of forest in the Amazonian region, Brazil especially, but also Paraguay, Peru, Colombia, Ecuador, and Bolivia. We are very worried about how Argentina is going to deal with fracking and the Vaca Muerta especially project, that is a huge project in all the southern part of Argentina. And we are especially worried, but I will show you a map in a couple of slides, but we're especially worried in the Andean region because our main source of water are glaciers, and glaciers are melting very quickly, and that could lead to huge desertification in the Andean region. This is the seriousness of climate change. How serious do we believe in South America and in Mexico and Central America, Latin America as a general speaking. We can also include the Caribbean in Latin America, generally speaking, and we are all very worried about this, especially in Mexico and Central America, but also in South America and the Caribbean. And it's a big difference with the US and Canada. I think there are many reasons, but as I said before, one of them, the most important one for me, is the fact that we are suffering the effects of climate change already. However, we are not big emitters of greenhouse gases. The bigger emitter in Latin America is Brazil by far, and most of the emissions from Brazil comes from land use change, from the loss of the Amazonian region. This is not very updated. This chart is not very updated. It's from 2009. I couldn't find a new one, but I believe that maybe in a new one we will see the same trend, maybe with a worst land use change and forestry part from Brazil because of Bolsonaro, but the trend is almost the same, and we are not a big emitter, but we emit some greenhouse gases. If we see the emissions divided by person, we find that the bigger emitter in per capita, the bigger emitter in Latin America is Venezuela, and this is particularly because of oil production, extraction, and selling. This is also not quite updated. It's 2016. This is the last chart that World Bank has about this point. But I think that also the trend should be very similar nowadays. Chile, our country, my country, Valentina's country, is the second emitter per capita in Latin America, and this is mainly because of minor activities and energy production to the industrial mining activities. And here we can see the emissions by world region. And if we look at this, we can see that South America, it's there in the middle with a light red or pink, or I don't know which color is it, but that color between Africa and North America. We are not big emitters. We are mostly receivers of the problems that climate change is posing over the world, and especially over our region. This is the map that I promised. When we look at the climate risk index, we can see that the Andean region is the one that is in a bigger risk in Latin America, and this is especially because of the mountain ecosystems and the fact that glaciers are melting very fastly. This also applies to half of Chile at least. We do probably they did here a kind of an average between the southern part of Chile that is less vulnerable in terms of climate change, but most of the population in Chile lives in the middle of Chile, which is also an Andean region. So we have the same problem. And here we can see the distribution of risk by countries and by regions as well. And we have there South America alongside with Asia, Oceania, Caribbean, Central America, and Africa. All the global South that is in a much riskier position than the global North, North America and Europe, that are more prepared for what is happening now and what is going to happen, what is going, hopefully not that bad, but it's going to happen anyway in the next 20, 30, 50 years. So we should stop this madness, no? And for stop this madness, or try to avoid some of the consequences, we as lawyers have the possibility of litigate. This is our ability. And I want to show you the rationales for climate litigation in Latin America. This is not a build over the actual cases that we have already, but also it's built over the legal institutions that we have in Latin America, some of them that are shared with all the Occidental world, some of them that are more embedded in Latin American legal culture. The first point that we have to take into, in this next part of the presentation, I will talk about these rationales and how they can be applied, or they have been applied in Latin American law. The first particularity that we have as Latin America maybe is that environmental rule of law in Latin America has to deal with the fact that property is usually a bigger right than the right to a healthy environment in our countries. And especially that the fact that property over natural goods, over natural resources is private, mostly, is private, is very protected by the rule of law, and it's in hands of the people that owns political systems and most of the economic activities in Latin America. This is a trend that is called hierarchical capitalism. You can see there is a book of from the MIT professor Bernd Snyder that reflects very well this reality. Our societies in Latin America are very unequal, but this inequality is also rooted in the fact that those that are in a better economical position are the owners of our resources, our natural resources, our natural goods. So you have to change this distribution and to change the privileged position that property over natural resources has. We don't need to change only some laws, but we need to change basically the structures of our countries. And this is very hard, especially because this structure, it's an answer to colonialism as a whole. So this structure is useful for the way in which our countries sell resources to the global north. So this is it's a geopolitical problem and not only an internal problem of each country. We taking into account that problem, taking into account that reality, we also have some good things in Latin America that we can explore and explode. The first one is that we have a very good disposition from judges to apply the principles of environmental law. And actually, there is a treaty, it's not a treaty, but something like a treaty that was signed by Supreme Courts in Latin America. This is a very weird international network, but there is a network of Supreme Courts in Latin America that signed a kind of a treaty about environmental principles and how to apply them in national law. And it's been the case of Chile, for instance. If you go to the Supreme Court webpage, you will find as one of the main things this document with the environmental principles. And these environmental principles are not only those that are rooted in Rio 92 declaration, but also some that has been part of a discussion and an evolution in jurisprudence in Latin America. And especially the Supreme Court in Brazil and the Supreme Court in Argentina and the Constitutional Court in Colombia are very active in the way that they are pushing for a better understanding of environmental problems and environmental law. So this is the case, for instance, of the in dubio pro natura principle. That it's a principle that has been mostly elevated to that point by the Brazilian Supreme Court. So this is a good point for our litigation. And the second good point for our litigation, the second good argument that we can use is the content of the right of a healthy environment and the way that the Inter-American Human Rights Court, has seen the right to a healthy environment. And this is especially the consultative opinion 23/17, which explores and makes a very important contribution to the way in which we can understand the right to a healthy environment in Latin America. And they include in that consultative opinion and the idea that the right to a healthy environment is not only embedded or connected with the right to life, but also that the right to a healthy environment includes the right to water, the right to food or soil, and the access rights. So the rights to access to information, participation, and access to justice in environmental matters. But it's not only that it has these points, but that consultative opinion has a development, has a way to write that it's very important for environmental law in Latin America. So we have these two good trends and our reality as a colony of the global north, but we do have rationales to fight against climate change from a law perspective. The first rationale is the right to a healthy environment, of course. And as Eva explained it before, and also Mai-Lan explained it before, there are many cases in the world that are based on this idea of the right to a healthy environment. Most of them are in the line of the mitigation approach. So most of them are connected with the lack of measures to protect the climate and the right to have a healthy climate, and connected to the lack of measures to protect a particular environment. And this second trend in the mitigation approach, in the rationale of right to a healthy environment, we can see that trend, especially in the cases that has been brought to court to protect the Amazonia. How do you say it in English? It's the same, Amazonia. the Amazonia has been protected by the Constitutional Court of Colombia. They actually recognize that the Amazonia has it's a subject. They have the right to nature, and this was because a case of young activists in Colombia, and we also have nowadays a case of young activists in Peru that are trying to copy the action of the Colombians one, and also to recognize the need to special measures to protect the Amazonian region in Peru. We haven't had this in Chile yet, but these two ways to approach to mitigation and right to a healthy environment are one possibility. And there is a second approach that is possible, that is the approach, the adaptation approach, and the lack of protection measures that the states are taking to protect their communities, their nationals. We don't have many cases of this, but I do believe that this will be probably the most important way in which people will try to force our states to cope with climate change. I mean, even when adaptation is not one of the main objectives from climate change policies in Latin America, it is our biggest problem now. We are following, as Latin American countries, we are following the global north approach to mitigation, which of course is very important. But as I showed you before, our emergency now, our urgency is not to mitigate, but how are we going to protect people from climate change? And that is something that the states are not taking into account, and that probably environmental lawyers will have to put into the agendas somehow. We can do this via constitutional actions, as it was done in Colombia, as it was done in Peru, or it is being done in Peru, or we can do it through civil actions, especially possessory actions. Possessory actions are a kind of action that is in the civil code of most of the Latin American countries, that allows people to protect their possessions, but also to protect some possessions that are from everyone, the common goods, the bienes nacionales de uso público in Spanish. And those actions has not been used yet in Latin American context, but are very close to the one that Urgenda used in Holland. So it's very likely that we can copy these kind of actions that came from the Roman law and passed to the European law and to Latin American law as well. So this is one possibility. Then we have a second rationale, and this second rationale has to do with, or is connected with, the environmental justice, mitigation, and the NDCs. So it's connected with the international obligations from the states. As it was said before by Professor Caim and Professor Morris, there are some obligations from the states that all of our states are in, that could be pushed as obligations that courts can force state to comply. So there could be, we can see there is not yet an action about this in Latin America, but I think that is likely to see an action pushing for the compliance of the NDCs. This is one possibility, and also there could be actions forcing for better NDCs in the reformulation of the NDCs that will happen every 5 years. We don't have this yet, but as I said, for instance, if we look at the NDCs in Latin America, they are very connected with the mitigation. They are not that connected with adaptation, and probably this will be an area of litigation and discussion in the next few years. And the third rationale, I missed an A there, but the third rationale is to use the idea of healthy environment connected with damages. And we also hear already about some of these cases, most of them that are being filed in European courts, in European tribunals. I believe because there is probably lack of confidence about the possibilities that national courts down here in Latin America will rule against big corporations like the ones that are producing climate change. So we believe, I think we here in Latin America, probably in Africa as well, we believe that it's more likely that the judges in the global north are independent enough to force big companies to do something, and we don't have that confidence in our judges. This is one point, and the second point is that probably there are more resources to do this kind of actions that are very costly in the global north than in the global south. I believe this because we don't have this kind of claims here in our courts, even when the claims about damages are about damages that are being produced in the global south. So it is weird somehow that we are not seeing this kind of litigation in our courts here in Latin America, but also in other courts in the global south. Climate litigation is growing in Latin America. I don't know how updated is the Sabin Center chart, the Sabin Center database, but I trust the Sabin Center database. It's probably the best database of climate litigation that we have right now. And according to that one, you can see how the cases is growing in Latin America. It's especially important in Brazil. Probably because Brazil in this couple of years is not connected with reality. So there is the need to push for better policies, no? But we can see this trend in every part of Latin America, almost the growth of climate litigation. In the case of Chile, we have 4 actions that are connected with climate change, but all of them are connected with particular cases, I mean, with particular projects and not with climate policy. In 3 cases, the discussion is about if climate change should be taken into account for the evaluation of new projects. 2 of them have been ruled against the environment, saying that there is no need to take climate change into account. One of them was in favor of the position of taking into account climate change. The important thing is that this one, which is Mina Cerro Colorado case, is the only one that has been ruled by Supreme Court. The other 2 are from environmental tribunals. Weird enough, our Supreme Court is more open to environmental protection than our environmental tribunals. Who will know, who will say. And the other case is the Wacolda case that it has another rationale. This one was about how a thermoelectric power plant that works since 40 years ago has to change the mitigation measures that are taken because of climate change and other changes in the area. But this was ruled against this idea, even when there was a minority vote that supported the need to change the measures of the plant because of climate justice. So this was an important openness, but at the end we lose by 3-2 in the votes in the court, the Supreme Court. So as conclusions of this presentation, we can say that climate change in Latin America is a challenge for law that is being addressed by constitutional and civil law, maybe not in the deepness that we will like, but it's being addressed and it's growing. The right to a healthy environment also can contain the right to a healthy climate and the obligation of the states to avoid damages, and this could be one area of growth of climate litigations. There are other human rights as well that are being damaged by climate change, and this fourth one, I didn't speak about this, but I do believe that the way that Paris is taking into account mitigation forces the people to push their governments to climate action, and this for me is a very good thing. I mean, we don't depend on the states. We depend on the people in every country. If the people in every country is fearless enough to push for change in their states, then we will have some better chances of saving the humans. Thank you.
Thank you very much, Ezio. You are optimistic, I see, always. So, yes, we don't have another way. So I will now read some questions. Thank you very much for your questions. And the first is from Toko Kaime, and it is addressed to Professor Eva Lohse, Mai-Lan Tan, and Professor Morris before Ezio Costa speak. And he is asking, as environmental lawyer, are we celebrating this line of successful cases too soon and too hard? He's thinking about the recirculation of references that characterizes scholarship in those fields. What elements should be in place, he's asking, both within domestic jurisdictions and at the international level, before we see a consistent body of comparative practice emerging. Who wants to answer, excuse me, before? Professor Eva, Mai-Lan, Professor Morris. Eva, I think you will answer. Yes.
It's a very difficult question.
Yes,
and
yes.
I can't put my finger down on any elements now. It's an interesting question. In a way, I think it depends. Well, let me start with that. Cross-referencing, I'm not a public international lawyer, but in the fields of national law, national jurisdictions, I would say it depends very much on the legal culture of the respective legal order. For example, I know that the case law of the European Court of Justice is referenced very much by some of the national courts, and other national courts, I don't know, they never reference the European Court of Justice. So I am not sure if you can say there are general elements that should be met. But what I think at the moment, maybe we are celebrating too hard. And I'm very skeptical actually about all this focus on litigation, because I'm not sure if this is the right way to change the mindset, the political thing. But I think what we can see, for example, the French court, it very much referenced all the other cases that happened in Europe, not globally, but said that there's the Heathrow case and there's the Ojeda case and so on, and then saying we're doing the same in France. So probably it's a political question, not a legal question at all, in my opinion. When do they reference? When do they not reference? Yeah, but yeah, I'm curious if anyone else has an idea about that.
Thank you very much,
I come back to you about that.
Any other comment? Mai-Lan.
Thank you. I also agree that it's really a difficult question, but I would say I'm maybe a little bit more optimistic. And I would say that we are not celebrating too soon or too hard. Because as we know, climate change is a global phenomena, and at least transnational corporations face climate litigation worldwide. So depending on jurisdiction and depending on the applicable law, they might face also climate change litigation in a country where there has been successful climate change litigation already, and there might be also jurisdiction in countries that are more likely to award damages, or that that are more friendly to such actions. And I think that we can also see already investors' reaction on the phenomena, because if such climate change litigation is successful, damages or cost for precautionary measures are really high. So they have to include those financial risks already now in their plans for their future costs. So I think that this also already reflects that there's this transnational effect. And as an insight from my work at the commercial law, we also have next week also a seminar about the consequences for the companies of these litigations. So I think that this shows that we already have really a good push from climate change litigation, even though it might be a little bit, even though there are only a few cases and not as many as we might like to have.
Thank you, Mai-Lan. Any other comments? Professor Morris, please.
Thank you. I also agree with the previous comments that this is one of the trickiest questions that one comes out to face. Probably if it had to be rephrased in a positive value, it would have still been, do we have any reason to celebrate anyway? If you take it from that perspective, then you will really find out that at least there's someone somewhere speaking for the environment. Now, if someone speaks now and he gives out an outline, the next morning, whoever is making a reference to the previous court decision, indeed is giving a leeway to make people see what the other people in the next door are doing. So it creates that particular credibility for people, not only in one country, but in other countries, to try and see boldly from one area, use it in their own domestic regimes. But again, if you're looking at the other elements that can be put in place, I would comment that, yes, the international instrument formulation is only put it to a national policy formulations and all that and that. But can we have something in that particular commitment where the nations are now going to be forced, or rather put to commitment that they will promote the court regime to lay a very good foundation to protect this particular line of climate? Because if you don't, if you simply let it from the sectoral emancipation, or if you let it to be matters of concern in terms of agriculture or the adaptation measures that you can take from ministerial and or intergovernmental sections, then if you don't specifically mention the court and give it a leeway of trying to put down and get confidence in interpreting some of these provisions to emancipate people from ignorance and people from that lack of commitment to fight. I think the international community can look at that from an angle where in the commitments they make the countries to abide to, this should be one of the areas that the courts should be promoted to constantly review and make interpretation of the domestic instruments to get line in the protection of the climate. Thank you.
Thank you very much, Professor Morris. I would like to put together two questions, one from Luis Gitiniwa and from Jevi Gonza. And they are asking, the question from Jevi is to any speaker, to what extent can we say that climate change litigation have played an effective role in bringing government or states to ensure strategic measures or changes in climate change? Is it useful? Is it effective? Can we say that due to the hurdles involved in litigation issues on climate change, it stands to be only an indispensable tool, but ineffective mechanism? So this is one question: in which extent is it effective, if I may to make a synthesis? And the other question is especially to Professor Lohse, but I think that maybe anyone can answer. It is about litigation is quite costly. It's about barriers in litigation, in access to justice, especially for many countries of the global south who must pay the price of environmental pollution and destruction committed by Western international and multinational corporations, the case of Shell. So is there another alternative or approach to follow without necessarily using litigation? Any other forum for action like the UN Special Mechanism, the UN Special Rapporteur of the UN High Commission for Human Rights? I think those are very interesting questions related also to access to justice, because if I can say, to have access to justice, you must before know that you have a right. So who wants to answer before? You are all invited to talk. Eva?
Yeah, I can go first, but I don't want to cut anyone short. Well, let me take the second one first. Of course, litigation is costly, and I'm only talking now about the public part, what Mai-Lan very nicely distinguished between public and private litigation, because I know that private law litigation can be very costly. At least for Germany, in public law, that's not the case. I mean, it's free to go before the Constitutional Court for everyone who claims to be violated in the fundamental right. I don't know about other countries, but I think that's the case in several countries. And also, administrative action is not as costly. It's actually quite cheap, because we follow this idea of saying, yeah, if the state violates a right, then it should not be your problem that you can't pay for it. So if it's really the costs, and then I think we should not think of that those people who are most effective need to sue or need to go before court, because that's what I kind of tried to say. We need way more ways of opening standing before the courts, and one very good idea is having standing of association, of NGOs, of people who can make altruistic claims, who can make class actions, whatever, if the national legislation allows for you to do that, because in that way the costs are not to be paid by the poor farmer somewhere, but by associations who have more expertise, who have more money, and who can pay a specialized lawyer or have a specialized lawyer. And I think that's, if we stick with litigation, that's the way forward. And I know that that's been done and that's been promoted. And also in Latin America, you know, have the very similar agreement to the Aarhus Convention, which kind of tries to establish that. So that might be one way. I'm rather skeptical with those international human rights bodies. I mean, yes, they can have political pressure, and I mean, there's a case pending on the UN Children's Rights Convention. But in the end, even if it's heard, which is not clear at the moment, if it's even admissible, in the end, it's not enforceable. It's a different case with the regional human rights courts, which kind of have binding decisions, but it's not enforceable. There might be political pressure, but I'm not sure if this is the effective way. And coming to effectiveness, Jebby, I'm totally skeptical if litigation is the right way. It might be the right way in the cases that Mai-Lan mentioned, like suing companies in a private lawsuit for indemnation, for penalties, whatever. Suing states or governments or whatever, a court cannot actually, force them to do anything. Even in the agenda case, in the end, I mean, it was a private law case, but in the end, if the Netherlands don't do anything, what are they going to do? Send someone to enforce it? We had a case in Germany where they tried to take into, I don't know what's in English, custody the Prime Minister of Bavaria, saying that he has not obliged with European law obligations on air pollution. In the end, it was not successful because you can't take someone into custody who has a public office for not convening with the laws, at least under our law. And I think it's the same in many jurisdictions. So maybe litigation is not the right way in a legal way of speaking, but it might be the right way in a political, just claiming that you should do something, and it might be effective in that way. Okay, that's my take on it.
Thank you very much. I invite the speakers to read in the chat because we are really on time. So maybe you can make a synthesis of the question. And please, Ezio, would you like to comment on those two questions? Effectiveness
of litigation
and barriers.
Barriers. We have a lot of barriers, that's for sure. And the only way that we remove barriers is by kicking them until they fall. And to kick them until they fall, we need to go to courts and litigate and litigate and litigate and litigate and litigate. It's the best strategy? No, maybe the best strategy is to the way that the world works and to change our system completely. But how are we going to arrive to that point? And in the pursuit of a systematical change has a lot of efforts that we need to do. Some people can go to the streets and scream and protest. Some people can go to Congress and change laws. Some people can go to courts and litigate. It is a good way, I think. Of course, it's not going to change the world by itself, as I think that nothing changed the world by itself. It's the addition of actions from people pushing the system that actually change things. And this is one of those actions. And I think it's a very powerful action. Not only because of the way that can lead to better climate policies, not only because it can bring justice to the ones that are actually litigating, but also because open minds in court, open minds in the people that are seeing these cases, it allows the public, the general public, to understand that maybe something that they see as natural, something that happens, is not that natural. It's an injustice, and the mere fact that they can see something that is going on in the field as something that is unfair can change the way that they approach to other actions. Can move people to the street, can move people to Congress. This is like asking if you are in the middle of I don't know, of a football match. It's like asking to the keeper if it is useful to be standing in the goal, no? And it's not, because if the ball is not in your part of the field, it's not useful to be there, no? But it has a function in the team. And in this case, we are a team all together. All the people that believes that we can change this trend of destruction to a trend of caring about life, we are a team. Maybe we are not that coordinated, but we have to do what we can, and litigation is one of those things.
Thank you. I think that Chilean soccer results are affecting you very much. Sven knows. Okay, no, thank you. It's a very good answer. I have another question from. I ask you firstly if do you have a few minutes more, because there are many questions. We should end, but I would like to read a few more questions. Okay. Okay. A question from Sven Corilius, especially for addressed to speakers from the German legal context concerning the rigidity of the of law, since related to the division between private and public law and administrative branch of judiciary and national and international. And so comparing with the other regions and other cultures, do you think that in other contexts climate litigation is easier, and the climate matter has an influence on the delimitation? He problematized it. I didn't read all the question. So do this rigidity, those divisions affect more the climate litigation in Germany, in the German law context?
I can pick up this point. So I think that we, as German lawyers, we really like to be dogmatic and not so much pragmatic. And as also my studies are still in my head, I know that we love our institutes, and I think that also still courts really like how they were educated at university, and instead of merging those lines between private and public law, I think we always try to integrate elements of other areas of law into the known, well-known institutes of our own discipline. So we try to contextualize questions of separation of powers, for example, into a duty of care. So did also the court at The Hague in the Netherlands, or not the German court, but they also integrated human rights, also the Paris Climate Agreement in defining a duty of care of a private amateur. So I think that there will be integration, but we will still stick to our rigid and dogmatic limitation lines.
Thank you very much. There is also any other comment to this? No? There is also a comment from Elia Mwanga about saying that in developing countries such as Tanzania, climate change litigation are prevented by a number of factors: poverty, poor human rights protection, and presence of new field of a relatively new field of environmental law. So her comment is that in countries such as Tanzania, even environmental rights are not specifically protected in the constitution. So I think that maybe if there is a question here is how to improve recognition of human rights in order to get a better climate litigation. I think maybe you have also give an answer with the factors that you have presented, but any of you have some recommendation in that respect or comment? No? Okay. Okay, and another question from Sven is about the polluter pays principle. That is, some of you have mentioned it. Who is the polluter who will pay in the end? And the day when a big company will pay millions for a big global damage, and that that will pass to the end consumer, and what happened with the social question concerning that. I think we can think in the yellow jackets. What happened with that? Would you like maybe Ezio to comment that? The social concerning when the polluter pay principle is applied.
Yeah.
Rapidly.
The social concern, the social concerns about the about how some services and goods are going to be expensive because of climate action. That's the point. Mm-hmm. Should be addressed via policies of just transition. The idea of just transition, and it's an idea that at least here in Latin America, it has some development. Some development is just starting. It was born as an idea of how to protect workers from polluters, polluters industries, how to protect those workers in the transition from the carbon economy to a new economy. And this point is important, but it's not the only point that we have to take into account in the just transition ideals. We also have to take into account how people that has been damaged by the climate change should not be the ones that will carry the cost of the new economy. And we should take into account how how climate actions will pose a cost on people in vulnerable situations. So if the price of cars goes up, we don't care. This is a very good thing. Hopefully, cars will be a luxury item in the future. But if the cost of bread goes up, then we have to worry, because bread is something that we all consume, and for vulnerable people, for poor people, is a very important item on the basic things that we buy to eat. No, so how do we address this second cost? There are many ways. The important thing is to have it in mind when we do policies for climate action. That if this is going to happen, then we have to create a tool to take this into account and to avoid this impact. So we have to avoid that food will increase their cost to people, but we don't have to avoid that other goods and services that are not essential, that are a contribution to the problem, will be expensive. And we need to do this differentiation, and we also need to have some education about what it means to have a transition. If we want to save our climate and our ecosystems, we will not have the same life that we have now in 10 or 20 years. We have to quit some of the things that we are doing. We have to quit some of the privileges or some of the things that we believe that give us more quality of life. And this is especially true for the global north, but it's also true for the global south. And a country like Chile consumes 1.7 planets. I mean, 1.7 resources times 1.7 times the resources that we could consume in 1 year if we take into account the limits of the environment. So the changes are not only changes in technology. We are going to change cars that emit that burn fossil fuels for cars that use electricity. If we do that, we're going in the same path that we are now, but with different technology. instead of going in that path with a motor that burns fossil fuel, we are going in that path with new materials. But the destruction is the same. So the change that we need is more deep, and that deepness has to come from people. I mean, it's not possible to have that change from above. It's the climate and economical transition needs a direction and a guidance from above as well, but needs the political will of the people. And that is why I think it's more important to build that will than to build a specific tools or policies right now.
Thank you very much, Ezio. Toko, Kaim were asking the...
Just a quick comment.
Eva.
Yeah, just a quick comment, agreeing with Ezio. I mean, climate change is the biggest market failure that we have seen. The reason that we having these problems from fossil fuels and all of that is because the real cost of using these kinds of energy sources have not been included in the true cost of these energy sources. So if we add the true cost, and this makes oil, coal, and other associated carbon-based energy sources uncompetitive, then so be it. That's good, actually, because it means that we will see the innovation that we need, bringing in renewable technologies and all of that coming online real quick. So to answer this question, as Sven poses, yes, there is going to be social disruption because these costs will rise. But at the same time, what we've seen with our economies is that new technologies take their place, and we're likely to see renewables taking their true place in our energy systems, because then the prices become really competitive. Okay.
Thank you very much, Toko. Eva, a last final word?
No, I was just going to say that's one of the reasons that I'm very skeptical about litigation, because I think courts cannot do this balancing issue, and they cannot decide on whether this or that measure would be sociable. No. So I think it's back to the parliaments. That's the best solution we have at the moment. And maybe you need new solutions on that side, but I think courts cannot do that, cannot be the ones that can decide on that.
Yes, it's also an important perspective. So this is the end. We have to respect the time and to really thank all the speakers. It was really very interesting. I think we are leaving with many answers and also many questions, so that is really important for us. I would like to also thank all the organizers, to thank Devi, Sven, and everybody who worked hardly to organize this event, this conversation, and also greets all those who have actively followed this conversation from different parts of the world and at different times, connected with this challenge, and that has to do really with the future of our civilization. I ask everyone to take care of yourself and your families and your close relatives and people, to be prudent in these pandemic times, and take care of yourself, and have a really good afternoon or night or rest of the day. I'm sorry because there are so many questions that couldn't be answered, but it's time to go now. Thank you very much. Bye-bye.